Ever pondered over this? Can a property transferred via grant deed be taken back by the grantor? This might seem like a complex question, but don't fret. Today we're going to unravel the intricate world of grant deeds and their revocation. A grant deed, as defined by the California Civil Code, is a document used to transfer the title of real property. It's a common form of deed, presumed to convey a person's entire interest in property to another person. But what happens if a grantor, thinking they are on their deathbed, transfers a property but then recovers? Can they take back the property? The answer isn't as straightforward as one might hope. Grant deeds, much like contracts, are legally binding once signed, unless specific conditions apply. In this scenario, the grantor may seek to rescind the grant deed, claiming it was conveyed by mistake. According to the California Civil Code, a contract can be rescinded if it was given by mistake or obtained through duress, menace, fraud, or undue influence. The California Supreme Court further clarifies that to rescind a contract due to a unilateral mistake of fact, the defendant must prove a set of facts. These include the defendant making a mistake regarding a basic assumption upon which the contract was made, the mistake having a material adverse effect on the agreed exchange of performances, the defendant not bearing the risk of the mistake, and the mistake being such that enforcing the contract would be unconscionable. Applying these principles to our hypothetical scenario, a grantor who mistakenly thought they were going to die could potentially rescind the grant deed. They would need to demonstrate that the deed was made based on the erroneous assumption of their impending death, and that this mistake had a material effect on the deed. They would also need to prove that they don't bear the risk of the mistake, and that enforcing the deed would be unconscionable since they are now alive and have lost their property as a result. So, in certain circumstances, it's indeed possible to rescind a grant deed due to a mistake. But remember, each situation is unique and necessitates careful evaluation. To summarize, a grant deed is a legal document transferring property ownership, and it's generally binding once signed. However, under certain conditions like a mistake, duress, or fraud, it may be possible to rescind the deed. But this requires meeting specific criteria as set forth by the California Civil Code and further clarified by the California Supreme Court. If you ever find yourself in such a predicament, don't hesitate to reach out to a real estate attorney at Shore Law for an evaluation of your case. They can provide the necessary guidance and help you navigate through the complex process of rescinding a grant deed. Remember, knowledge is power. Understanding the potential for valid revocation empowers both donors and recipients with crucial insights into the complexities of legal ownership and the cancellation of grant deeds. Stay informed, stay empowered. Need legal assistance? Contact the Los Angeles attorneys at Shore Law today to set up a consultation.